Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm Head of Culture and Engagement here at Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar, Navigating PAGA Reform, a guide to understanding a helpful but confusing reform measure. Some housekeeping notes for today. If you have any questions during the webinar, please feel free to type them into the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During any additional Q&A time we have at the end of the presentation, I'll be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we'll gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded, and at the conclusion of the webinar, the recording link as well as a copy of the slide deck will be forwarded to you. We have an incredible expert sharing with us this morning, but I'll let our own Vice President of Healthcare Risk, Keck Royce, have the honor of introducing him. Welcome, Keck.
Thank you. I'm excited to introduce Erin Silva, who's the labor and employment attorney and partner with Murphy Austin Schoenfeld, um, where he leads the labor and employment practice team. Erin has an extensive background defending employers before state and federal courts and several administrative boards. He advises companies in all areas of employment law. Erin is a frequent speaker and hosts the monthly podcast, HR Legal Cast. I am excited to welcome Erin Silva.
Good morning, everyone. Nice to be here with you today. So here we are, PAGA. Again, my name is Erin Silva. I'm the chair of the Labor and Employment Department here at Murphy Austin. Murphy Austin is a full business law firm, so general litigation, business litigation, real estate, construction, all that sort of stuff. But one aspect of it is labor and employment, which is what I do. Essentially exclusively, but I'll go into general litigation sometimes. But labor employment law is my specialty. And as far as the litigation that I do, I would say probably within about the last 7 years, PAGA litigation is at the top as far as what I'm doing. And for most employment attorneys that are on the employer side like me, I think that that's usually a common thing. So let's do just some housekeeping things. Right there, you're seeing terms of use and disclaimer. I'm an attorney, so there, of course, needs to be a disclaimer. Next slide. That's a picture of me. So you can, well, you can go back. So that's a picture of me, and that's me speaking there at the top, and that's what I looked like about 4 years ago. But let's go to the next slide. All right, so let's go ahead and dive into this. So PAGA, the Private Attorney General Act of 2004. So that's what you are here for. So let's do a little deep dive into what it was, and then we'll talk about during the rest of this presentation about what it has become. So there's all this stuff in the labor code. And if you don't know what the labor code is, that is the set of laws that we have here in California that address employment matters for the most part. They're in some other places, but for the most part, it's the labor code. But there's all these things in the labor code. And some of those things say, okay, you're not allowed to do X, Y, and Z. But it doesn't say what the consequence is if you don't do X, Y, and Z. So you don't do X, Y, and Z, you're not, in compliance with the law, but what's the penalty for that? It wasn't necessarily clear. And then there's other things where if you do them, so you do X, Y, and Z, it does say that there's a penalty. Usually it's a monetary penalty, but only the state was able to go in and get those penalties and recovering them. So at the turn of the century, there was a concern in the legislature that, hey, we just don't have the resources here stateside to go get all these penalties. So we have employers that are breaking the law. There's remedies that are available that only the state can get. But we don't have the state resources to actually go and get them. And on top of that, there's these other things where there's no penalties whatsoever. So what do? So what the legislature and Governor Davis at the time, on the way out of his way out of office, did was come up with this Private Attorney General's Act of 2004. Private Attorney General's Act is where we get the acronym PAGA, which is what I'm going to be referring to it to. So basically what it allows, it allows an aggrieved employee to sue their employer on behalf of the state of California for labor code violations, right? So what is happening is that the employee or one of the employees that is aggrieved by some sort of labor code violation is allowed to step into the shoes and become effectively deputized as an attorney general to go in and get those penalties on behalf of themselves and on behalf of other aggrieved employees. Now, the default penalties were, and I want to emphasize the were, although they still generally are, although now you'll see the caps, is the default penalties for some sort of violation were $100 per employee per pay period for an initial labor code violation. And then for subsequent labor code violations, it was $200 per employee per pay period for each subsequent violation. And then successful plaintiffs, if they brought a PAGA claim and they recovered 1 cent, were entitled to their reasonable attorney's fees. So the employer, if an employee recovered 1 cent, would have to pay not only their own attorney's fees, but the employer would also have to turn around and pay the employee's attorney's fees as well. So you're probably saying, hey, that probably went both ways, right? So if an employer was entirely successful, they would have the employee pay their attorney's fees, right? That's only fair. Well, it's California. So no, it doesn't work that way. It is a one-way fee shifting statute. So only employees were able to have the other side potentially pay for their attorney's fees as well. And it was because of these attorney's fees that PAGA became so popular. Because quite honestly, the labor code is incredibly complex. So the likelihood that an employer is 100% in compliance with it is unfortunately somewhat rare. There's just a lot of ways to mess up under the labor code. And anyone that comes to Bender's, year-end presentations about new employment laws, I've done several of those in the past. You know that every year we're getting brand new laws that are complex and more complex and more complex. So under the old PAGA system, an employee goes, they file a PAGA lawsuit, they're aggrieved about something. Let's say they recover $100, right? They never just recover $100, but let's say it's $100. In that situation, under the old law, $75 or 75% of the penalties that were recovered would go to the state. And the agency that would get that money is the Labor and Workforce Development Agency. And then the remaining 25%, so in my example, $25, would then go to the aggrieved employees to be split amongst them. Next slide. All right, so why did PAGA become so big? It didn't start off very big. When it was like 2005 and 2006, I want to say there was like less than 100 PAGA notices that were filed every year. So just to let you know, to get a PAGA lawsuit going, you have to give that agency, the LWDA, the one that gets the penalties at the end of the day, you have to give them notice at the very beginning and say, hey, I intend to sue my employer for these violations. State, do you want to come in and do this? And then the state has a certain amount of time to say, yeah, we want to do it, or no, we don't want to do it. But more than likely, and most often, the state says nothing. And then the employee has now done what's called exhaust their administrative remedies, and now they can come in and file their lawsuit. So filing a PAGA notice is the first step that you have to do before you file a lawsuit. So back in the day, at the very beginning, there weren't very many. Because people didn't really understand it. And what happened was that class action lawsuits, which are very similar, they're brought on behalf of multiple employees. That was what was popular. But anyways, back in the day, not very popular, but it became very popular. So in 2023, there were over 8,000 PAGA notices that were filed. Quite honestly, if an employee is bringing a class action lawsuit or even a wage and hour lawsuit, right? In my opinion, if you're a plaintiff's attorney and you're not filing a PAGA notice, you're not doing your job. So it's very, 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 very common. So what was also happening over time is that court decisions that were deciding the scope of PAGA were almost exclusively favorable to employees. So the courts were taking, the opportunity to expand the scope of PAGA to make it bigger and the liability amount higher. But in my opinion, what really made it explode is basically what happened with class actions. So to do a class action lawsuit, so say I didn't get paid overtime, there's these other employees that didn't get paid overtime. I'm going to file a class action lawsuit. I'm going to try to represent those employees, and we're going to try to get that unpaid overtime that we didn't get. Well, to have a class action lawsuit go forward, there's certain requirements that you have to satisfy. You have to have a certain number of employees. You have to have common issues of law and fact. Your claims as the plaintiff need to be typical of the other employees that are in the lawsuit. So there are these prerequisites that need to be met. Now, a PAGA case is very similar. So say I didn't get $100 in overtime, right? The only way that I'm going to recover that is if I sue to get that $100, for instance, of overtime I didn't get. PAGA is different. PAGA is not getting the $100 that's owed to you. PAGA is getting you the penalties for not paying the overtime. So the difference between PAGA and a class action is in a PAGA lawsuit, it's effectively a class action. It's collective. You're bringing it on behalf of other people, but you don't have to satisfy those class action requirements. In other words, it's a lot easier to maintain a PAGA lawsuit. And in around the 2010 to 2013 area, we found out that class action lawsuits can effectively be waived by effective arbitration agreements. Right? So that made them a lot less attractive to plaintiffs' attorneys. That didn't apply until somewhat recently to PAGA. So a few years ago in PAGA, we got a US Supreme Court case that said individual stuff, individual PAGA claims. These are, I didn't get my overtime. Those can be subject to arbitration if you have a PAGA claim. But if you're seeking to, have other claims that you didn't necessarily personally suffer, so my issue is I didn't get overtime, but these other employees, they didn't get breaks and they didn't get correct pay stubs. That's called a representative claim. So the individual claim can be subject to arbitration, but not necessarily representative. So that's why PAGA became so much more popular with the plaintiff's bar. Now, employers didn't like this, obviously. I mean, the numbers we're talking about for settlement are incredibly high. You get a PAGA lawsuit. I mean, it was not uncommon and probably common to get six-figure settlements, right? Even for the most minor of technicalities. So a pay stub doesn't have a piece of information on it. 300 grand for a settlement. I mean, it's just outrageous, right? So employers didn't like it, obviously. So what happened is that employers gathered together and they tried to get an initiative on this ballot for 2024. It's called the California Fair Pay and Employer Accountability Act. It had qualified for the ballot, and basically it was going to repeal PAGA and replace it with something that was a lot less draconian for employers, right? Well, plaintiff's bar didn't like that, and the plaintiff's bar has the ear of the legislature and the governor. So what ended up happening is on July 1st of 2024, after some negotiations, the governor signed two bills that came through the legislature, which were compromise bills, to effectively reform PAGA in order to avoid the possibility of PAGA being repealed on the ballot from happening. So governor signs these two bills, which we'll go over, and then the initiative that was going to go on the ballot isn't going to proceed. So that's what ended up happening there. Next slide. All right, let's jump into what this thing actually does. Okay, so these are just overviews. We'll get into a tremendous amount of detail about what the thing does. But overall, this is a reform bill. There are two reform bills, like I said. One was in the Senate, one was in the Assembly. And they're really complex. When I put together this presentation a few weeks ago, I was using the bills, to put it together, obviously. I was doing summaries that were coming out of the governor's office. Cal Chamber did a good one. Other law firms do it as well. It took me 6 hours to put this thing that you're seeing right now together. Some of it's very easy. Some of it is incredibly complex, and you'll see that with the cures. So this is not a simple piece of legislation. And I think you will see over the next 5 to 10 years a lot of case law about it. I do think overall it is very helpful for employers, but some parts, because it is a compromise, right? I mean, the governor and the legislature are not looking out for the interests of employers, in my opinion. They're more in line with the plaintiff's bar, right? So the plaintiff's bar needs to get something out of this deal as well, in addition to employers. That's why it was a compromise, and that's what you're seeing here. But it is very complex. So anyways, here's the overview. So the PAGA reform applies to any civil action that was brought on or after June 19th, 2024. So basically, if you get, and it's the same thing with a PAGA notice. This is for more recent stuff. So if you have a PAGA lawsuit that was filed before June 19th, 2024, or you have a lawsuit that is based on a PAGA notice that was filed before June 19th, 2024, this isn't going to apply to you. This is going to apply to the old stuff. but it is going to apply to stuff going forward. The next major component of it was, if you might remember, the allocation of any penalties recovered. It was 75% goes to the state and the remaining 25% goes to the employees. It has now been adjusted a little bit, so 65% of those penalties are now going to the state and the remaining 35% are going to aggrieved employees. Back in the old version of the law, you could only get these penalties, but now you can get injunctive relief as well, and of course, attorney's fees and costs. And then there was this, and actually, I was one of the litigators early on back in my associate days that litigated this subject. So, class action, one of the things that is very relevant is, can a court really manage what the claims are, right? A class action can, at a certain point, be too big, right? So, for instance, maybe you have a class action where the problem is that people are misclassified, right? So I had a case back in 2015, and it was about chemists, and they were classified as exempt employees, but the plaintiff argued that they should have been non-exempt. So really, that came down to what were the duties, and there were different types of chemists in this class action as well. My court, determined that that wasn't manageable, that we can't try all these claims together because there's so many individual facts. The question was, did that same reasoning apply to a PAGA case? Are there PAGA cases that are so broad and there's so many individual facts that need to be litigated that it's just not manageable, and we need to whittle this thing down and dismiss certain aspects of it? There was a split, but the California Supreme Court very recently said, no, there's no manageability. This reform law came in and seems to suggest that, yeah, you can make a manageability argument now, which would be great for employers. So that's the actual language that's quoted right there on the slide. The Superior Court may limit the evidence to be presented at trial or otherwise limit the scope of any claim filed pursuant to this part to ensure that the claim can be effectively tried. I think that that's saying manageability exists, but I'm sure that topic is going to be litigated thoroughly in the years coming up. Next slide. Okay, so let's talk about some of the specific things that are happening in this legislation. So for these first few slides, I talk about a specific problem and how the legislation tries to fix it. So problem number one, plaintiffs actually have to suffer the violations that they're suing about. So here was the problem. Back in 2018 and subsequent, we got a few other, or at least one other case that said the same thing. We got this Huff decision. And the Huff decision basically said that if the worker alleged that they experienced a single PAGA violation, that they could sue for all PAGA violations on behalf of all other employees, irrespective of whether they, the individual plaintiff, suffered that violation or not. So I have a little example there. So let's say we have an employee, a plaintiff that's filing a PAGA lawsuit, and the only violation that they're claiming is that on one occasion they did not get a meal break, right? Under this Huff decision, that plaintiff could also sue on behalf of other co-workers who didn't get overtime or didn't get rest breaks. That's not a problem that they had as the individual plaintiff, but the Huff decision was allowing for plaintiffs, for a single plaintiff who had one violation, to sue on behalf of everyone. So you can see why these PAGA lawsuits got very, very big, right? Now it's not just, usually it's called standing. If you're going to sue someone, it's a violation or it's an issue that affects you personally, right? The Huff decision allowed it to, you didn't have to have standing plaintiff on everything that you're suing for. You just had to have standing on one individual thing. So you might remember a few slides back, I said that the courts had really been very expansive with PAGA. This was the prime example. So what's the fix out of this legislation? Aggrieved employees, so those that are suing, now must have personally severed each of the violations alleged in the lawsuit. So if you go back to my example there, if the plaintiff claims that they only were deprived of a meal break on one occasion, that's the only thing that they can sue for. They could not sue for on behalf of other coworkers who didn't get overtime or didn't get rest breaks. In my mind, that is one of the top things that this legislation gets employers. Next slide. You may know what the concept of statute of limitations is. Statute of limitations basically means that there's a certain time period after a harm was suffered that you have to file your lawsuit. There's a variety of reasons why we have statute of limitations, but usually it's because over time people's memories fade, right? So if you had a wrong that happened to you 20 years ago, the likelihood that you're going to remember all the details about that depending obviously on what the harm is diminished over time. So that's why we want these things prosecuted or litigated in a more timely manner. Memories are more fresh. That's just one of several reasons why statute of limitations exists. But there nominally was a statute of limitations for PAGA. But of course, that got expanded. So this case here, the Johnson case, and there was another one, but it's a 2021 case. The court said that an employee whose individual claim is time barred, so statute of limitations apply, may still pursue a representative claim under PAGA. So even if their claim is time barred, they might be able to go pursue violations and penalties on behalf of other employees, irrespective of the time period. So it was unclear if there actually was an operative statute of limitations for PAGA, which was a problem. So, when I was litigating these things, and, I should say when, I still do, but when I was litigating under the old version of the statute, I mean, sometimes I was looking back to like 10 years, right? If there was some sort of violation or something like that. And that was just horrible. So it was really unclear if there actually was a statute of limitations. But there is a fix under this compromise legislation. Alleged violations must have occurred within the last year, which is good news. Next slide. Okay, defining subsequent violations. So you might remember when we talked about the default on one of the original slides is if there is a violation, there's a penalty. So an initial violation, there's a penalty of $100, and then for every subsequent violation, there's a $200 penalty. Well, the problem was it wasn't necessarily clear what an initial violation was and where that ended, and when a subsequent violation ended. So take for the example, you have an employer that in 1 week didn't provide a meal break to an employee. So Monday through Friday, right? So under the plaintiff's interpretation of this language, the penalty would be $100 for Monday and then $200 subsequent for Tuesday, Wednesday, Thursday, Friday, right? And the employers came back and said, no, the penalty is $100 for every single one of those days, unless someone has previously noted, like a court or an agency, that your policy effectively is wrong and you're not properly paying these people, right? There had to be some notice to the employer in some sort of legal context that there was actually a violation. That's when a violation happened. But anytime before that time, it was an initial violation. So an initial violation could last for years, right? Plaintiff's bar didn't like that. Employers obviously did like that, and there's a big argument because at the end of the day, there was no binding court decision which resolved that issue. We do have a fix for that. So basically, the $100 initial penalty is going to be the default penalty. The $200 subsequent penalty amount is only going to apply if an agency or a court found within the preceding 5 years that the employer's policy or practice that caused the violation was unlawful, right? So that's giving notice. The other situation where the $200 subsequent penalty is going to apply is when the court finds that the employer's conduct that gave rise to the violation was malicious, fraudulent, or oppressive. That's effectively the standard that applies for punitive damages. It's a very high standard. So we'll see how that goes. I would imagine that most plaintiffs are now just going to argue that every violation was malicious, fraudulent, or oppressive, but it's a high standard. So this is another one of those good things. So now we know, because effectively it cuts the potential liability in half, based on what employees would say that an employer might owe for a violation or subsequent violations. Next slide. All right, so now we're going to get into some very specific things, and you will see that some penalties are potentially eliminated under PAGA now. Some penalties are greatly reduced under PAGA. I mean, there's a lot of things that are happening in this legislation. So let's take this step by step. So eliminating some penalties, neither willful, knowing, nor intentional. And a lot of this stuff is vague. So it's going to be litigated to figure out what's going on. So these are just overall impressions based strictly on the statutory language. I will say when I put this presentation together, as I typically do, and even when I do my podcast, I was interested to just see what other law firms are saying about it, because law firms all the time are putting out their updates, and you can get these online. there's not consensus among both the employer and the employee's attorneys as to what is actually happening with all this stuff. That's why I'm saying it's going to be litigated. But if you're seeing it here, it's coming essentially directly from the statutory language. And of course, there is a lot of stuff where there's consensus. But here's the problem, right? Plaintiffs often sought derivative penalties for the same violation. So I'll give you an example here. So you got a former employee, and they say, I didn't get paid overtime. So they would seek a PAGA penalty for not only just not getting the overtime, but they would seek derivative stuff, right? There's lots of things that fall based on someone not getting paid properly, right? So that probably means that they've got an inaccurate pay stub. It also probably means that they weren't timely paid, right? So what was happening is that when plaintiffs were, for instance, doing a wage claim, so an overtime claim, for instance, they would say, "Hey, I need to get the penalty for the unpaid overtime, but I need to get the penalty too because the pay stub wasn't right, and I need to get a penalty too because those wages they weren't paid. That means they weren't timely paid, and then I need to get a penalty too because if the employee is a former employee, they needed to get all compensation that was entitled to them when they left. They didn't get that. So I get another penalty. That's called stacking, right? So you got one violation, but you're stacking penalties on top of it. Once again, we didn't have any court decision here in California that directly addressed that problem. And that was huge for employers. So we do have a fix under the compromise legislation. It says employees cannot recover civil penalties in addition to the underlying wage violation or the underlying unpaid wage violation. And then we have a list of categories here where they can't get that derivative stuff. So number one, failure to pay timely wages that are due upon separation. Those are called waiting time. Unless the violation was willful or intentional. Next category, that's the failure to just timely pay wages. So these are, this could apply to both former and current employees. The first one would only apply to former employees. But it's a failure to timely pay wages unless the violation, again, was willful or intentional. Next level is can't get derivative penalties for pay stub violations when the underlying thing is based on non-payment of wages, unless the pay stub violation is knowing or intentional. And then the next thing is it's a failure to provide wage statements is something that can't be stacked. So that's great, right? So in that situation, if unfortunately you weren't properly paying someone their overtime, for instance, the penalty in this situation at least would just be for overtime, and you couldn't stack it with these other violations and penalties that are listed in this slide. Next slide. All right, so that was potentially eliminating some penalties, right? So stacking. Now we have the concept of capping some penalties, right? So remember, you go back to the default. What's the default? $100 and then $200 for subsequent. Well, there are certain things where there's going to be a cap depending on what has happened. So most of it applies to pay stub violations and isolated violations. So for pay stub violations, you might know that there's certain information that needs to be on a pay stub. It's listed in Labor Code Section 226. That's the main law. There are other laws that address this as well, like paid sick leave. But 226 is the main law. So that's the law that says, hey, on a pay stub, you need to have rate of pay and you need to have hours of work and you need to have gross wages that are earned and net wages that are earned and all deductions that apply. You need to have the employee's name and their employee ID or the last four of their social security number. You need to have the employer's name and you need to have the employer's address, right? So there's lots of things that need to be on a pay stub. So as far as capping violations or capping penalties for violations, the first layer that we have is for pay stub violations. So there's something that's not on a pay stub. So we have a $25 cap, and there's actually two $25 caps for pay stub violations. But when a pay stub is incorrect for reasons that are unrelated to having an employer's name or address on a pay stub, the cap applies, the $25 cap applies if the employee could promptly and easily determine from the wage statement alone the accurate information, right? So this doesn't have to do with employer name or address. So say, for instance, you don't have a rate of pay, but you do have on the pay stub the hours worked and the net wages that were earned in its own line item, right? So an employer could do a little bit of math and figure out by taking their wages earned, dividing by the hours that that were worked in that pay period, right? What was the hourly rate of pay for that? Now, obviously, it gets a little bit more confusing if you have more than one rate of pay or there's overtime. Presumably, you have itemized. Each level of wages is itemized. But point being, if you could do some math to figure out what is the missing information, then you're going to get this $25 cap. The other $25 cap applies when you now have a pay stub violation, but it's related to an employer name or address not being listed on it, or it's incorrect or something like that. Now, this happened all the time. You'd be surprised, an employer might just have their name on there, but there's no address. The employer has a DBA, so their legal name isn't on there. There's some sort of weird parent relationship. There's a parent corporation. So there were a lot of pay stub violations that related to accurate employer information on there. So this $25 cap under our compromise legislation applies if an employer would not be confused or misled about the correct identity of their employer. So if there's something on, obviously if you have an employer name on your pay stub and it's just the wrong company, you're still going to have those $100 and $200 penalties are going to apply. But if it's something like it's a DBA that's wrong, or I saw things where it says LLC instead of incorporated or something like that, right? You would get PAGA penalty cases out of that. If it's something simple and employers not being deceived about who really employs them, then this $25 cap is going to apply, which is very good. Then you also have a $50 cap. This is unrelated to pay stub stuff. So a $50 cap applies when the violation was caused by an isolated, non-recurring event that lasted less than 30 days or 4 consecutive pay periods, whatever is less. So a very, very isolated thing. And that sometimes happens. So, you get a transition in your HR manager or something, and they don't, there's a late payment of wages or something like that. Those isolated things happen, and this is addressing that. Next slide.
Well, I actually have a question for you, Aaron.
Go for it.
For PAGA claims filed before June of 2024, what is the likelihood reform may influence awards or mediation? Or are there pre-reform claims plaintiff's attorney's last opportunity to maximize penalties or mediated damages?
Yeah. So the question is, so you remember that the law affects basically PAGA lawsuits that are filed after June 19th, 2024, or where a PAGA notice was filed before June 19th. So June 19th is like our operative date, right? So you're talking about a lawsuit that was filed before June 19th. So maybe it was like in January of this year, right? And I have several of those, right? This litigation isn't, or this legislation for the most part isn't going to directly legally affect those things, right? So all of the old law is going to apply to it. So I would fully expect that the plaintiff's bar is going to just basically say that this compromise legislation, we don't really care about it. Now, good defense attorneys are going to argue that it does. I don't know how much success they're going to get. I'm definitely going to try that, but I haven't been in mediation on a wage and hour thing since June 19th. Right. I think I might have my next one next month. So we'll see. But for the most part, I just don't think that employers are going to get the benefit of this legislation for pre-existing PAGA legislation. I will say, because I got a couple of buddies that work in the legislature, so this was my question because it wasn't clear at the very beginning when this law took effect. I was calling them up and sending them texts like, "Can you have your members find out what's going on here?" And I eventually got the June 19th date. It's in the legislation now, but they said from the information that we're getting, and this was like because the compromise was announced like June 17th, so it was like 2 days before the June 19th thing came into play. There was like a frantic rush from plaintiffs' attorneys to get PAGA notices in, so they could get the benefit of the old law effectively. Okay, next slide. All right, capping more penalties. So here is a problem. Remember, PAGA penalties, the default is $100 per employee per pay period. Okay, so if you pay 2 times a month, if you paid every other week, which is my preferred way, by the way, if you did that, so your penalties would be less than an employer that paid weekly, because an employer that pays weekly is effectively has 52 pay periods. Whereas if you're paying, every other week, you've got 26 pay periods. And if you're paying, 2 times a month, you have 24 pay periods, right? So if the penalty is $100 per employee per pay period, if you're paying weekly, you're getting hit a lot harder. And the industry, in my opinion, that got hit the hardest on this is the construction industry. The construction industry, it is incredibly common that they're paying weekly. So their penalties were almost for the same you had the same employer, same violation, but one employer is paying every other week, and you got an employer that's paying weekly. It's the same violation, but one employer is paying effectively double the penalty amounts just because they happen to pay weekly, which was incredibly unfair, but it was what it was, right? So there is a fix here. So the compromise legislation says that for penalties for employers that are paying weekly rather than something else, those penalties are reduced by 50%, right? So it's trying to equal the bar a little bit. I know that's not necessarily 100% equal, but it makes it a lot better for those of you that are paying on a weekly basis. Next slide. All right, so what's this? We have even more penalties that are capped. This is good stuff, right? We want things that are capped. We want things that are reducing our liability. And this legislation addresses several areas that get things capped. This is the third slide we've had about it. It's good. So all reasonable steps. Let's talk about all reasonable steps. Now, if an employer takes all reasonable steps to comply with the law, their penalties are capped at different percentages depending on when all those reasonable steps are taken. So penalties are capped at 15%. So we'll take the default of, $100, right? So it could go down to 15%. Penalties are capped at 15% if all reasonable steps are taken to comply with the alleged violation before the PAGA notice is received or a request for personnel records is received. So let's talk about that. We talked about what a PAGA notice is, right? That's the thing that goes to the state. Hey, state, we're going to sue the employer for this, but we're going to give you first dibs at it. If you don't want to take it, we'll come and do it as the employees. And the state never does anything, right? So what's the personnel records thing? Employees have the ability to request their personnel records outside of litigation. Now, I've seen the list of the people that are on this call. I know some of you have received letters from attorneys. There's two firms in particular that send out a lot of these letters that say, hey, we want personnel records, we want pay records, we want time records, right? That's what this thing's referring to. So if you take all reasonable steps to comply with the law before you get that PAGA notice or you get that request for personnel records, this cap potentially applies, but you got to take all reasonable steps. The next level of capping with all reasonable steps is they're capped at 30% if all of the reasonable steps are taken to comply with the alleged violation within 60 days after the PAGA notice being received. So pro tip, if you get a PAGA notice, don't ignore it. They're incredibly important. You need to reach out to your attorney if you get one of those things. Next slide. What's all reasonable steps? Good question. That's why I have a slide about it. All reasonable steps are evaluated by the totality of everything that happened, but it's considering things like the employer's size, their available resources, the nature, the severity, and the duration of the alleged violations. But all reasonable steps the all reasonable steps capping doesn't apply when the violation was malicious, fraudulent, or oppressive. Sounds familiar? Probably should, because we just talked about it a few minutes ago. That's effectively a punitive damage standard, so it's very high. So the existence of a violation in and of itself doesn't dictate whether or not reasonable steps are taken. So you can take reasonable steps, and that cap could apply even if at the end of the day you had a violation that occurred. Of course, it couldn't be a violation that was malicious, fraudulent, or oppressive, but take reasonable steps. So pre-PAGA notice, so remember this is where you potentially get it capped at 15%. So pre-PAGA notice, pre-request for personnel records. What are things that an employer can do to show that all reasonable steps are being taken? Well, you could do a periodic payroll audit and take appropriate action if you're finding problems. You could utilize lawful written policies, train supervisors on wage and hour compliance, or you can, take appropriate corrective action with regard to supervisors. I quote that because I don't necessarily know what that means. So we'll see what happens. But basically, do an audit, go train your supervisors on this stuff. Here at Murphy Austin on head of personnel, aside from being the chair of the Labor and Employment Department, I'm also the chair of the personnel department or the chair of the personnel committee here. So of all the Murphy Austin employees, I chaired that, right? So I went and I trained all my supervisors when this legislation came out. It was like 10 minutes just to go over what's overtime rules, what are break rules, stuff like that. When it was at my partner meeting, I made sure it was on the agenda so we had a record that it happened. But you can do this stuff now. And I would encourage you to do this stuff now. These are all good things. Audit your stuff. Take a look at your pay stubs. Update your handbook, which should be updated on a yearly basis. Make sure that it's compliant. Okay, next slide. Defining all reasonable steps, part 2. Now we got the post-PAGA notice examples, right? So this is where the 30% cap applies. So how do you take all reasonable steps? Once again, sounds familiar. Conduct an audit of the alleged violations and take appropriate action in response to those audit results. And then, use lawful written policies as to the alleged violations. So, maybe you have a rest break policy that says you have to stay on the premise. You can't leave the premises during your rest breaks, right? So based on, case law that we got several years ago, that's not lawful. You would change that. Next thing you can do, train supervisors. And again, take appropriate corrective action with regard to supervisors. So pro tip, diligent employers are taking all reasonable steps now, right? This is stuff you can do right now. In addition to all of the other training you need to do, right? Presumably you just got done with your training on your workplace violence prevention plans. If you haven't, you need to. But this is other training that you need to do as well. There's lots of training you need to do as employers, and it happens on a yearly basis at the very minimum. Okay, next slide. Okay, now let's talk about cure. So cure, now you have a PAGA violation. Cures can be taken to effectively really reduce your liability or potentially eliminate it. So this is the mixed bag, and we'll talk about that. So certain violations can be cured. I'll give you some examples there. Break violations, minimum wage violations, OT, failure to reimburse personal expenses, and pay stub. Now, it is unclear if it's always advantageous to cure based on the complexity of the process, which you'll see here in a few minutes, and the information that you're providing to a plaintiff's attorney. Keep this in mind. The statute of limitations for PAGA is what? You know this. It was one of the first slides. It's 1 year, right? That was one of the fixes that we got. But again, a PAGA case, let's say it's overtime. I didn't get $100 in overtime. A PAGA case is not getting the $100. That's not what the employee is recovering. What the employee is recovering is the penalty for not getting paid the overtime. If the employee wants their $100 in overtime, they have to file a lawsuit. They can do a class action lawsuit, right? Now, here's the difference. PAGA statute limitations to get that penalty, 1 year. Wage violations, statute limitations to do that, 4 years, right? So you can get a lot more money potentially if there actually are violations if you have a class action, and get the most money if you actually combine a class action with a PAGA case as well. Okay, keep that in mind. It'll be important here in a few minutes. Next slide. Okay, so there's different cures for different type of violations. And of course, as you can see, pay stub violations were very, very popular and are very, very popular with PAGA. But there's different cures for different types of violations and different type of pay stub violations. So the first cure relates to employer name problems on a pay stub and addresses, right? So we talked about that, there were some caps on that, but now we have a cure. So you would now get a PAGA lawsuit. What can you do? How you have now been alleged in a formal administrative proceeding or in a lawsuit of having deficient pay stub violations because your employer name or address is deficient somehow. So those can be cured if the employer provides written notice of the correct employer information to each of the aggrieved employees in the PAGA period. And the notice may be provided in some sort of summary form. So you don't actually have to provide each pay stub, like reissue them, right? So it can be provided in summary form, but it must identify the correct information for each pay period in which the alleged violation occurred. So that's one of our easier cures. Pro tip, you can check that now. And you should, once a year. It should be part of that audit for all that reasonable steps you should be taking. Print out a pay stub, a model pay stub, and go to the Labor Commissioner's website, or you can type in Labor Code Section 226, and you're going to see the general requirements. There are additional ones as well, but that's the easiest one. Compare them and see if you have a violation and fix them if you need to. Next slide. Okay, curing pay stub curing for all other pay stub violations. So for pay stub violations unrelated to the employer name or the address, they can be cured if the employees are provided free of charge compliant pay stubs for each pay period during which the violation occurred during the prior 3 years predating the PAGA notice, right? And if pay stubs are usually provided electronically, corrected pay stubs can be provided through, quote, reasonable access to digital or computer generated record of the pay stub. I just quote that language because that's actually how it appears in the statute, but the way that I read it is digitally would be acceptable if that's how you usually do it. And it's a reasonable access and they don't have to pay for it and stuff like that. Next slide. And now we go to curing again, but now it's a non-pay stub violation. You got to make an aggrieved employee whole, effectively. For non-pay stub violations, they're only considered cure if the alleged violation is corrected, the employer is in compliance with the underlying statute subject to the PAGA notice now, and each aggrieved employee is made whole. Now, if an employee is owed wages, how do you make them whole? Pay attention to this because this is starting to get complex and it's going to get a lot more complex here till the end. So how do you make someone whole when they're not paid all the wages that they're entitled to? So the employee needs to receive an amount sufficient to recover those unpaid wages dating back for 3 years. 7% interest is paid on the unpaid wages. If there's liquidated damages that are required, like minimum wage, those need to be paid. And then reasonable, what's called lodestar attorney's fees and costs are paid as determined by the agency or court. That's great. I don't know how, as an employer, you find out what the attorney's fees and costs are paid because it says that it's as determined by the court or agency. So presumably, this is information that the plaintiff's attorneys are going to provide to their counterparts on the employer side, like me, maybe like in a mediation or a settlement communication. I hope that's how it works. This is just one of those things, and you'll see a lot of them going to the end of the presentation. I just don't know. But that's information that, as the employer, you don't know, right? And as the employer's attorney, I don't know. I mean, I know what my attorney's fees are. I can guess what my counterpart's attorney's fees are, but I don't necessarily know. So this is information that there's going to have to be some sort of cooperation to have that information exchanged. Otherwise, this cure for unpaid wages just isn't going to apply because you're never going to be able to make the employee whole. Next slide. So deadlines to cure violations. Different deadlines, different effective dates. It depends on if you're a small employer, so you have less than 100 employees, or a large employer, which has more than 100 employees. This is the part of the presentation where I was putting together where I would say that I probably spent about 4.5 of those 6 hours. And you'll see why. So if you're a small employer, now you cure the deadline or you cure the violation, but you got a deadline to cure that violation. So let's talk about the process to do that. So you're a small employer. Now this only applies after October 1st, 2024. What happens before then? Like right now? Don't know. But effective October 1st, 2024, if you are a small employer, you have 33 days after receiving a PAGA notice to give the LWDA. Remember, that's the state agency that gets the notices. That's also the agency that gets the 65% of the penalties recovered. You've got 33 days to give them a quote unquote confidential proposal to cure one or more of the alleged violations, right? Now, once you do that, within 14 days of the proposal, the state may, doesn't say has to, but it says may set a conference that is then within 30 days to determine if the cure is sufficient, what additional information is needed to evaluate the sufficiency of the cure, and the deadline agreed to complete the cure. Now, if the state agency concludes that the cure is not facially sufficient or it doesn't act upon the proposal, the employee may proceed with filing the lawsuit, although the employer has the ability to request a stay with the court when the lawsuit is filed and request an early evaluation conference. Next slide.
I actually have a question for you, Aaron.
Go for it.
Um, since majority of PAGA cases are mediated, what are recommended strategies for mediation to both reduce cost of mediation and outcome of damages negotiated?
All reasonable steps, in my mind. I mean, we're going through what the cures are. These are all possible ways that you can limit your liability. But in my mind, stuff that you can do now before you even have the PAGA liability or the PAGA lawsuit is take all the reasonable steps. So go back a few, you don't have to, I'm not saying literally go back a few slides, but go back to a few slides when we talked about all the reasonable steps. In my mind, that's what you're doing now, right? And then, we talked about the caps that potentially apply, but in my mind, it's all the reasonable steps. So all of this stuff is somewhat of a guide now as an employer to figure out how you can reduce your liability. But in my mind, the number one thing is all those reasonable steps because any employer can do that now, and that drastically reduces what you're dealing with. So
Thank you.
next slide. Okay, so we're still continuing along with the administrative process here for small employers, right? So now let's say you get that conference, right? Within 45 days of the conference that is conducted by the state, the employer has to complete the cure, unless otherwise agreed to by all the parties, and provide a declaration of its completion, in addition to a payroll audit and check register if the violation involves some sort of payment obligations, so some sort of underpayment, right? Thereafter, the state has 20 days to verify if the cure is complete, and then the state will notify the employee if it verifies, in fact, on behalf of the state that the cure is completed. Now, how's the employee or more specifically their attorney going to react? Probably not positive, right? So the employee has the ability to challenge those findings. And if that happens, a hearing on that challenge needs to be held within 30 days of the determination. And then the state has 20 days from the hearing to issue its conclusions about the adequacy of the cure. If the cure is upheld, the lawsuit may not proceed, although the employee now has the ability to appeal all this stuff into the superior court system, right? That's where they would file the lawsuit anyway. So they're challenging the cure. And then the superior court, that's the lowest level of our court system, then gets to determine whether or not the state abused its discretion in making the findings that it did. Do you see how complex that is? I mean, just if you go through those two slides, the amount of different, hey, here's 45 days, and this is 30 days, and this is 33 days. I mean, it's incredibly confusing. If you are an employer and you get a PAGA notice, you need to retain counsel fast, right? You've got 33 days to do something if you're going to cure it. You got to act fast. You can't sit around and just wait for the lawsuit, or you potentially lose the ability to do something with these cure options. Okay, let's go to the next one. Okay, large employers. The other one, remember, for small, the cure deadlines apply after October 1st. Well, if you're a large employer, it's effective immediately. So you don't have to wait till October 1st. So if you are sued under PAGA and you're a large employer, what you can do when you're doing your cures, which we just talked about, right, is you can request an early evaluation conference, which will stay the lawsuit. I mean, basically, it's going to ice the lawsuit for a little bit. What's an early evaluation conference? Doesn't say. What are the goals of the early evaluation conference? It does say, and that's our next bullet point there. So, it's intended to evaluate if any of the alleged violations occurred, and if so, whether they were cured, the strengths and weaknesses of plaintiff's claim and defendant's defenses, whether the plaintiff's claims can be settled in whole or in part, and whether the parties should share other information to resolve the dispute. That sounds a lot like mediation to me. It's not clear if that's actually what's happening, but those are the goals, right? So let's talk about some of the process to deal with this stuff. So employers that request the conference have to provide a statement regarding that whether or not they intend to cure any of the alleged violations, specify the violations that they actually will cure if they're going to cure anything, and identify the allegations that it disputes. Next slide. Now you've requested your conference. Now the lawsuit is being stayed and the court has to do a few things. It needs to schedule that conference within 70 days. Who does that conference? Lawsuit doesn't say. Is it going to be a judge? Is it going to be a mediator? I don't know. We'll have to see what ends up happening. Now, within 21 days thereafter, the employer who states it intends to cure any or all of the alleged violations must submit on a confidential basis its proposed plans to cure those violations. Then it's going to direct an employer that the court is going to direct an employer that disputes any alleged violations to also submit a confidential statement explaining for the basis in the evidence for disputing those claims. It will then, meaning the court, direct the employee to submit within 21 days of the employer submitting their cure plan and confidential statement to submit also on a confidential basis the factual basis for the alleged violations, the amount of penalties claimed for each violation and the basis for that calculation, the amount of attorney's fees and costs that are incurred to date, any settlement demand, and the basis for accepting or not accepting the employer's proposed cure plan. Here's the problem with that. Anyone that's ever had a PAGA lawsuit, the plaintiffs are not in the ability to tell you direct dollar amounts until you exchange information with them, usually how many employees are involved in the lawsuit and how many pay periods they worked. Why? Because the penalties are based per employee per pay period. So this is really early on in a lawsuit. Unless an employer gives that information willfully over to an employer or an employee and their attorney, I don't know how an employee's attorney is going to calculate this stuff. So that's one of those practical problems. Next slide. And then deadline to cure. This is our third slide. We continue on with the process because the process continues. If the neutral evaluator accepts the employer's proposed cure plan, the employer then has 10 days to provide proof that the cure has occurred. And if the employer fails to do so, the stay is terminated, the lawsuit goes forward. If it's agreed that the cure actually occurred, that's an agreement between the plaintiff's attorneys and the defense attorneys, which I'll be interested to see if that actually happens. The parties present to the court the terms of their agreement, and if no alleged violations remain in dispute, then the submission is essentially created like a settlement, or it's treated like a settlement, and that's something that has to be approved by the court. But if alleged violations remain in dispute, the court can defer consideration of the parties' agreements until a later time. And then if it's not agreed that a cure actually occurred, the employer may ask the court to approve the cure in conjunction with evidence that they support, showing that the cure actually happened. Let me give you a little bit, or actually, let's go to the next slide because we do have pay stubs. There's different deadlines for curing a pay stub violation. So if an employer only seeks to cure a pay stub violation, it must provide notice of the cure to the state within 33 days of the PAGA notice. We've heard that 33 deadline before, right? The notice of the cure must include a description of the actions that were taken. If the employee disputes that the pay stub violation actually was cured, they have to provide a written basis for that to the state. The state then reviews the actions that were taken by the employer, and then it provides a written notice of its decisions of whether or not the cure actually occurred within, here's a new date, 17 days of being notified of the dispute. Now, if the state determines that the pay stub violation has not been cured, the employer may proceed with their lawsuit. And if the agency determines that the alleged violation has in fact been cured, but the employee still disagrees, the employee may appeal that determination to the Superior Court, and now you're litigating the cure. Can we go back one slide? I want to make a point about all this. So this is why I don't necessarily know if these cure things are going to be good and if employers are actually going to use these or not, because as you can see, there's these confidential reports that are going back and forth between the employer and the employee, and basically the employer saying, hey, here's the problems that I had. I was violating the law, but I cured them. Remember when we talked about statute of limitations? Why wouldn't the plaintiff's attorney just say, okay, well, the statute of limitations for a PAGA case is 1 year, so maybe I don't have a PAGA case, but the employer is admitting potentially wage and hour violations. So maybe they're saying why they didn't pay overtime correctly. Why wouldn't they just turn around and file a PAGA or a class action lawsuit that has a 4-year statute of limitations? So even though it's a confidential report, and it does say it can't be used actually as evidence of anything. That's true. It can't be used in evidence as creating liability. So you couldn't present it to a court or to a jury and say, hey, look, in this confidential plan, the employer said that they weren't properly paying overtime. Why wouldn't a plaintiff's attorney, though, they can't use it for evidence, but effectively you've given them a roadmap for violations that exist. Why not try to get more money for a longer period of time in the class action realm. And that, of course, is, there's a lot of nuance to that. But that's one of my big concerns that I have with this cure stuff. So we'll see how that ends up working. But overall point with the cure stuff, incredibly complicated, as you can see. But other thing is you need to reach out to your attorney as soon as you get those PAGA notices because you're going to have to make those determinations. Okay, so we can skip over a couple of slides. Questions? According to my clock, we've got 21 seconds left in the presentation until it's exactly an hour, but we can go beyond that. Any questions?
Yes, we do.
Yeah.
So, a question: what's the likelihood LWDA does not have the bandwidth to respond to cures within the multitude of timelines specified? What do you
Incredibly,
think the outcome of their failure to respond to be?
incredibly high. Incredibly high, right? The whole point that we have PAGA is that that agency didn't have the resources to go out and collect all those penalties, right? That's why we made all these deputy attorney generals. It's not like this law is giving that agency more money or telling them how to do things. I don't know how they're going to comply with it. I mean, but it may just be inaction. Some of those cures, we went over through a lot of them. It says, well, if the LWDA doesn't do something, then the employee can appeal into superior court. So there's a lot of defaults. I don't know how they have the resources. I don't know how the court has the resources to comply with these timelines as well. I mean, I got one case here in Sac Superior Court, which is where I'm based. I practice all over, but my main court is usually, it's regional, but it tends to be Sac Superior. To just get a motion heard on like a discovery dispute or something like that, they're setting it out like 4 months in advance. So I don't know. It's a really good question. I I don't know.
All right. Should I notify my insurance carrier if an employee requests their info?
Yeah, so you have the obligation to uh, provide notice to your insurance carrier if there's a likelihood of some sort of litigation. Now, if it's just some employee that asks, on their way out the door, hey, I want my personnel file, you got 30 days to comply with that request. But if you're getting one of the attorney letters, and like I said, there's two firms that in particular do this. Um, Usually, it says something along the lines of, "Hey, we're requesting these documents because we're investigating, likely violations of the labor code, or we think this person was wrongfully terminated." If there's something in there that indicates, hey, this is more than just a request for records, then yeah, you absolutely should. And you may want to, even if you just get the personnel request. I mean, it depends on your insurance company, it depends on your policy. So I'm just talking generally here. But just because someone requests their personnel file or their time records or their pay records doesn't necessarily mean that they're gonna sue you. It's not a good sign, in my opinion. But especially if they're doing it individually, but if they have an attorney, that's when I start getting suspicious, and I would be a lot more open to let my insurer know.
Erin, can
Thank
I
you.
jump in as well
Sure,
for that question?
sure.
I always recommend my clients send in that notice of circumstance, even if it's just on their way out, they're requesting their files, just because a carrier can decline because that circumstance, even though there's no claim, there's no a letter from an attorney, they can still possibly decline because if it's a claims made policy, which is usually what we have in this situation. And so it's better to put the carrier on notice. It doesn't necessarily negatively affect their insurance. It is just putting the carrier on notice. So that way, if a claim ever comes, you've already satisfied their notice of reporting of a circumstance requirement that they have.
Yeah, yeah, yeah. And I'll defer to the insurance specialist because, like I said, it depends on your policies, stuff like that. And I'm just talking generally, but
Yeah.
doesn't sound like
Great.
there's an issue with it. Okay.
All right. For small employers versus large employers, what constitutes 100 employees? Is it full-time only employees or is it
Not
part-time
to
and full-time?
Not defined. Not defined. So we'll have to see how it pans out. If I'm looking to litigate or to other laws, similar laws, I'm probably going to be looking to like something like a FIMLA or CFRA explanation. But usually it's not just full-time employees. Usually it's your part-time. Usually there's a look back period as to what it is. But it doesn't expressly say. As far as I recall, it doesn't expressly say. But I can guarantee you it's not going to just be full-time employees.
Okay, perfect. And we're just going to take two more questions just to
Yeah.
be sensitive of time here. What should an employer do when they get their PAGA notice?
Well, as I said a few times during this presentation, I can't emphasize it enough. You need to reach out to an attorney real fast. So the PAGA notice, it's not going to be like some official document. It's going to look like an attorney letter. Usually, it's probably 5 to 10 to 15 pages. Um, so it's going to be the attorney writing to the LWDA and saying, "Hey, we intend to file a lawsuit." And then there's going to be this laundry list of all these bad things. And usually they throw everything in there that they possibly can. And a lot of employers just, because it doesn't require you to do anything in and of itself, right? But as you can see in this presentation, when you get those letters, it's triggering deadlines, right? So depending on your size, cure deadlines in particular, right? Or even uh, um, the all reasonable steps exception, after you get a PAGA notice, right? So it's triggering something. So it's reaching out to someone that knows something about it. And if you don't know an attorney, you can always reach out to, your insurance folks, if you know any in this presentation, that I'm sure would be willing to refer you or get you going in the right direction.
Wonderful. Thank you. Last question for today. What are some steps that we can take now to avoid PAGA liability?
Yeah, so it's the all reasonable steps thing. So what is that? That's the audit. So, and by word audit, that doesn't necessarily mean that you have to like hire an outside professional to do that. Check your pay stubs, check your time records, right? Are you making sure that employees are clocking in and out? Are they clocking in and out for lunch? Um, that sort of stuff. So the audit, the training of the supervisors about wage and hour stuff. Like I said, when I did my training of my partners here, because they're all supervisors, I think my presentation was like 10 or 15 minutes. It was very, very brief, but it was comprehensive, right? So do the training, and then of course correct any problems that you have. But a lot of it has to do with training those. It depends on the industry that you're in, right? But training your supervisors to really understand. Hey, when someone's on lunch, don't ask him anything. Just don't talk to him, right? If it looks like it might be lunchtime, or they're doing something, ask them if it's lunch. Ask them on their if it's on their break or something like that. If you're more white collar and maybe you get an email from your assistant over the weekend, right? Did they clock in? Are they claiming that time to make sure that they actually got paid? It's being on notice for that sort of stuff, right? And that's really about supervisors having an understanding of just what are these base requirements, because as a lot of wage and hour in California is very complicated.
Excellent.
Okay.
Thank you. We will go ahead and wrap up our questions. But again, if you have questions after the webinar wraps up, feel free to reach out to us and we will gladly connect with you and help you out. Thank you, Erin, for sharing with us today. We really appreciate
Absolutely.
your time and expertise. We appreciate you all for taking time out of your busy schedules to join us for today's Bender U. As a reminder, this session has been recorded and both the recording link and a copy of the slide deck will be emailed to you following the webinar. Next up for Bender U next month, we have what's in the crystal ball for commercial real estate and insurance. It's going to be a great one. That's going to be on September 26th. If you want to scan this QR code, this will take you to our full lineup of Bender U classes where you can register. But again, any questions, feel free to reach out to us, and we hope to see you at a future Bender U. Thank you again, and we hope you have a wonderful day. Thanks,
Thank
Aaron. Thanks,
you.
Jack.
Thank you.
Bye, everyone.